John Laws began broadcasting on radio in 1957, and as of 2021, he still hosts a morning talkback show. He is known for being prepared to say controversial things, and on a number of occasions, this has led to complaints to the regulator. In March 1987, he criticised public expenditure on Aboriginal affairs and broadcast inflammatory caller comments on that issue. Complaints followed, in particular a complaint that he had contravened the broadcasting standard prohibiting a person from gratuitously vilifying a group on the basis of race. A subcommittee of the Australian Broadcasting Tribunal made the decision that Mr. Laws had breached the relevant standard and recommended a public inquiry as to whether his licence should be restricted or terminated. A senior officer of the tribunal was interviewed on the radio and said that Mr. Laws referred to Aboriginal people in derogatory terms and consistently implied that they were getting preferential treatment and that they were no-hopers and that if they got off their backsides they could fix everything up for themselves anyway. Mr. Laws commenced defamation proceedings against that officer and the tribunal. He then argued that the tribunal could no longer consider restricting his broadcasting licence because of apprehended bias. He claimed that the officer's statements on radio on behalf of the tribunal raised the perception that she and the tribunal had made up their minds. Under those circumstances, there could be no confidence that the tribunal would bring an open mind to the decision. The court rejected that argument but went one step further. Chief Justice Mason and Justice Brennan said that even if there was apprehended bias, the operation of the rule of necessity would ensure that the tribunal is not disabled from performing its statutory functions. The rule of necessity permits a member of a court who has some interest in the subject matter of the litigation to sit in a case where no judge without such an interest is available to sit. The rule of necessity gives expression to the principle that the rules of natural justice cannot be invoked to frustrate the intended operation of a statute, which sets up a tribunal and requires it to perform the statutory functions entrusted to it. If the whole tribunal was conflicted out, then no decision could be made at all, and the purpose of the broadcasting legislation would be defeated. The court would not allow this to happen.